Hey everybody, the Irish Demon here, back with another video, just kind of changing things up a little bit here. I haven't actually watched this just yet. I've seen it around the place a little bit, so I'm going to do a bit of a live reaction to it. This is a case concerning some squatters in a motel, so let's get stuck straight in. She looks confused.
Good morning. Are you Paige Martin?
Come on, man. You can do it. Press the microphone button. You can do it. There she goes. No? Maybe?
Good morning. Can you hear me?
Yes.
There we go.
All right. Could I ask you to put your cigarette out? We're in a court proceeding.
I know. I'm sorry. I'm on my my break at work. I didn't.
No, you're in
know I was
court.
supposed to do this until like an hour ago.
Well, where is Jonathan?
He called me and said that his phone is not allowing him to get in it, but he's trying.
All right. Your landlord wants you to move.
I don't live there, Your Honor.
You don't live there?
I have
So you
never
don't care
lived
about-
there. When my husband and I were kind of estranged, and I moved away, and he asked if I would help him put a payment on a room, and I did, because obviously I still want him, to be in our son's life. Right now we're communicating and trying to work out everything, but so they needed an ID, and he didn't have it on him. It was packed in his stuff. So I gave them my ID, and he was told, as soon as he gets it, just bring it up. And I guess he did. So I don't know why this is still in my name, but yes, Your Honor, I've never lived there. I live in Marcellus.
All right. He says your son was in the hospital. Is that accurate?
Yes, my son has come down with influenza A for a second time this year. That's actually where he's at right now. My son is with him, caring for him.
But he's not at the hospital. He's at home.
Nope, he is at home. He was in the hospital yesterday. We got home super late.
All right. So Jonathan is still there, as far as you know?
Yes.
With your children?
My son, yes.
Again, I haven't seen this, so I don't know if he even answers. I'm not really sure. Oh, wait, I've seen thumbnails, so I think he does.
Hello?
There he is.
Is this John Martin?
Yes, it is. I'm sorry.
All right. This is Judge Middleton. We're all here in court in file 231725. This matter was set for 10:30. Paige Martin has joined us from her work. Mr. Andrew Rognus is here. Mr. Patel, the owner, is here, and some other witnesses are here. This matter has been bumping along for months. The landlord wants you to move. We learned from your wife that her ID got used to rent this room, but she's never lived there. You live there, but you haven't paid any rent since September. You were in one room, and then they moved you to another room because the heat went out or something, but they still wish to evict you. We're here on February the 2nd. I ordered you to be here live in person today for this hearing because you always show up late and you always have a terrible connection. But your wife advised and you advised that your son is sick and you're home with him. So, Mr. Rognus, is that your representation? You still wish to have the eviction? The defendant has not paid any rent since late September.
That is correct, Your Honor. Your Honor, if in fact he's got problems with his child, we could probably wait till Monday to, do the writ.
All right.
Give him the weekend to get his child cured back up again.
The writ already entered, but the room was changed because they moved you. Mr.
What's that
Martin,
face
what's
she
your
just did down
position?
there? Did you see that?
With all due respect to the owner of this place and as lawyer, I understand that what has to come, you know what I'm saying, the eviction or whatever. But I have been looking online on the 3B court district thing for like case to see if anything was coming for an eviction. I explained in court that I, you know what I'm saying, I lost half my finger. I'm still trying to like figure out how to deal with life with that. You know what I'm saying? I know that the eviction has to come, and I'm fine with that, but I just don't feel like, you know, I have this youngster hand me a letter saying, hey, this is from court, and they got court in like 20 minutes, dude. And then I come get in court, this court hearing that doesn't even have anything to do with my name. It's because of this lawyer or the owners mess up and not putting the right name appropriately, addressing things, and then fixing the error whenever it happened and kept trying to sweep it underneath the rug. Now, I understand.
Stop, Mr. Martin. I don't care about any of that. You used your wife's ID to get this room. You've been living there October, November, December, January, and February, and you've paid no rent. You
It's
have clear
ridiculous.
notice of every hearing. And all you've done is whine and complain that you didn't get sufficient notice. You got notice. You've been living there for 6 months without paying any rent, and you use your wife's ID to get in there. She's never even lived there. So they're willing to give you until Monday. Monday is a court holiday. So I'm going to give you until next Tuesday to be out, or you're subject to being evicted.
Question.
Yes, sir.
So just for the record, because I'm going to pursue this outside of court into the next steps, I'm not going to be given a fair through right process like everybody else is.
Do right process. Oh my God.
You've been given a fair process. There are
one piece of paper with a name on it that's not mine, and I made it to one hearing, and now it's this a week later. Like, that's not even 30 days. You know what I'm saying? Like, normally you get the notice to quit, which is what, 7 or 10 days, and then you have the first formal hearing, then you have the second formal hearing. Like,
Your Honor, he's a trespasser. He doesn't get a notice to quit.
Yeah, like, so he says, I was only able to turn up for one hearing. It's like, it's your fault that you didn't turn up for all those hearings. And not only that, you're supposed to be there in person today, and lo and behold, you haven't turned up again. So how is that everybody else's fault? I just don't get it.
Yes, everything is in your wife's name, and she's not there and has never lived there. And so you're complaining that you've got 6 months worth of free rent. Well, they don't want to do that anymore. So you have until Tuesday, which will be February 20th.
but they're not even being on. Like, is Mel there? Is Mel here for the court hearing?
Yes, Mel is here.
Okay, so at one point when I did come in and pay, I gave my ID to Mel, and they had my ID, so I don't understand why this is a problem.
Okay, so on one hand, you contend they're not doing the right person. On the other hand, you contend it should be you. The bottom line is, I already did a writ of eviction, but there was a different room number because they moved you to a different room because of no heat. So you were supposed to be out 6 weeks ago. We've had several hearings since. You've paid no rent. So they're giving you until February 20th. So I'll sign the order. We'll send it to that room. And you've got till next Tuesday, actually probably Wednesday, before the sheriff comes to your door. Paige Martin, do you have anything to add?
I mean, honestly, Your Honor, like when I got the room or whatever, it was
Will you
in an understanding that it was.
Stand still. You're making me dizzy.
I'm sorry, I'm really late going back into work. Like, I'm gonna get in trouble.
Okay.
It was in an understanding that, the room, like his ID was going to be taken, and, and I understand, things are the way they are, you don't pay, obviously, but, I have a little sympathy. Like, he did lose most of his finger, you know what I'm saying? In a freak accident. And his disability, that's the only thing that's wrong is, he's got to wait on disability, or he would have it would have been paid. He had a job, he was paying, and you know, an accident happened. You know what I'm saying? It's not like he's deliberately saying, you know, F you, like I'm not gonna pay. You know what I'm saying?
All right, thank you.
All I can think of there is J-Rock from Trailer Park Boys. No, I'm saying.
All right, get into work.
All right,
Mr.
thank you so
Martin?
much, Your Honor.
You're good to go. All right. The date for the writ. I'll just sign it on the 20th.
Will they then just throw that up in the basket for Bruce?
I have it here.
Okay. Thank you, Your Honor.
Thank you, sir. Thank you very much.
All right.
The absolute audacity of somebody to think that they can just get free rent for months and months and months like that. And then try, like, it's one thing to just go, yeah, okay, I haven't paid it for months, but can you give me a chance to pay? Or can you give me a little bit longer because my kid is sick? And don't get me wrong, I sympathize with them for that. But like, you're talking about a half a year of free rent here. Like, this man deserves to be paid. It's his property. These people are just using it and not paying for it, right? And then his excuses are all about, I wasn't able to do this. I didn't do this. Yeah, exactly. You didn't do it. And then he tries to go down the route of, oh, but why am I getting it for somebody else's name? You live there, dude. You're responsible for the place. Like the whole squatting thing, like, I don't know. I think maybe the laws are a little bit maybe too relaxed on that kind of thing. Like if I owned a place and somebody was squatting there and not paying up, obviously you're going to give somebody a chance. Like that's just basic human decency and human nature. Don't get me wrong. Especially if they're going through bad times, you try to work something out. But I don't know, like maybe you let me know what you think if you're watching, if you own property, or maybe, you know, we're thinking about it, or, you know, just in the event that you might own property, do you not think you should just be able to go, right, okay, I'm done with you, get out, and just drag them out because it's your property? But I get it. I get why the laws are there. It's to stop people being unnecessarily thrown out or wrongly thrown out or whatever. I totally get it. But it just seems so unfair for the people that own those properties. But as I say, let me know what you think. If you like this style of video, do let me know. I know I got a lot of flack the last time I tried this because I interjected way too much. And hands up, that is true. But I do like these kind of live reactions, especially the ones that I've never seen before. And any of these that, you know, I find on other channels or whatever, I'll of course give shout outs and things like that. But I know a lot of people want me to react to stuff that has been covered quite a bit before. So I'm kind of, you know, I'm on the fence about it. I do like to kind of catch the stuff live in court. But you let me know what you think, and we'll catch you all in the next one. Sláinte. Hey everybody, the Irish Demon here. Sorry I'm not on screen. I'm actually away from the studio, away from home at the moment. But I wanted to bring you this very interesting court case, and I'd absolutely love to hear what you have to say about it. This young individual, I'm not sure whether or not it's somebody who identifies as male or female. I'm not 100% sure. But in any event, they claim that their grandmother has kicked them out of the house because she doesn't agree with this particular individual's way of life, or whatever way you want to put it. But it seems like there's a little bit more to it. It seems like there's been a lot of very aggressive action. You can see the attitude of this person is pretty crappy at times. But definitely let me know in the comment section down below what you think of this whole thing, and we'll catch you in the next one. Sláinte.
Did you guys get a hold of?
Yes, Judge. Jarmany's completed the RIP, and we learned that the complainant lives with the grandmother and the mother lives in a separate residence, but neither of them want contact with the defendant.
What are we supposed to do? I mean, is he right where at 17 he can still be required to live there?
I know, Your Honor, Michael's right that 17 is the age of adult in Texas, so I don't know if by law he's required to live.
Show me that. Where's the authority? I mean, if you can show me that, okay. But, you know, I don't know where to put him.
I understand the age, Judge, but I don't know what else to say other than.
I get it.
And the bigger issue is that an intake prosecutor took the time out of their day to call me, tell me, Mike, you got to talk to Judge about this because he's a danger to these people. They do not want him there. He intends to keep forcing his way there. There needs, in in our position is there needs to be some sort of legal protection for the complainant, so they have some sort of recourse, you know, because they call the cops and the cops see his stuff in there and they're like, okay, well, I can't do anything. You know, at the end of the day, he's an adult. He's indicated.
Show me
to the
that.
court
Show me.
already.
You're saying that at 17, he's an adult, that he can
He's
be
got
out.
somewhere to go.
But show me where. I mean, where does it say that at 17, he's considered an adult as opposed to 18?
In the state of Texas, Judge, I'm talking
Your
about,
Honor,
just at least for purposes of the law, what we charge people with. I guess that's what I meant. Is 17 for purposes of charging somebody criminally, that's an adult. That's why he's here.
and Your Honor, even further in section 51.02, subsection 2 of the Texas Family Code,
Okay, hold on. That's what I want to see. Okay, section, what?
section 51.02 in the Texas Family Code, and then subsection 2, and it defines what a child is, and it says under 17.
That's what I want. A child means a person who is 10 years of age or older and under 17 years of age.
What are you thinking, Judge?
I don't want to put him on the street. Like, I don't want to do that.
He's not on the street. He's indicated to you he's going to stay with his best friend.
Let's see what he
I'm
tells,
homeless.
Mr. Brooker.
Yes, Judge.
Um,
I understand the concern, but I mean, especially because he's come to you telling you, I got somewhere to go. You know, maybe we could follow up in a week, put him back on the docket, make sure he's not living on the street. I'm sure there's resources the court can provide to get him housing if he really needs it.
let's see.
Yes, Judge. Yes, Judge.
I can ensure that he's got a place to go.
Yes, Judge.
Judge, are we gonna need to resolve?
Yeah, I want to make sure he's not using any kind of dope or anything, you know. Maybe I should have drug tested him too.
We have some case reviews.
Okay. Shatari, let me just finish this real quick. Stay here.
Should I be right?
Uh-oh. Hi, Roseanne. So you got 5,002 on Young, right? Vic? Okay, I think that's it then.
Judge, was that, did you sign everything?
Well, I haven't even gotten to that. Something's wrong with the computer.
Judge, to add a bit further context, Jarmanese, when she spoke to the witness, said that the defendant has a history of violence against the grandmother as well. So he's previously committed these type of assaultive conduct, which is why they don't want contact.
I understand. So on that gentleman, no drugs, no alcohol, random urinalysis, no contact with the complaining witness or the grandmother, no weapons. I'm not going to put it on monitor now, you know, but if he shows me that there's an issue or if you guys get wind, then we'll do something. You ready to have Mr. Barrett come up to sign the condition? Are you ready?
Yes.
Okay.
What's that?
Barrett. He needs to sign his bond conditions.
So sorry.
Okay, sure.
I put a motion in there for Mr. Hahn. He was supposed to come to court today and turn himself in to go to DDRP. He didn't show up. Just letting you know. I'm sure you're gonna want a motion for this guy too.
Wait. What did you put in here? I don't
A
see it.
motion. I don't know if they made it ready.
I have an MRP coming your way. Someone was to come and turn themselves in today
239.
for probation and they never did.
Also,
I know.
Please. It's not yet, but it's coming.
yes, Judge.
And then the next guy, he just picked up a new charge. He's on probation for assault. He just picked up a DWI in Brazos County. The cause number is 248-281.
Crumbles?
Yes,
Yep, issue the warrant.
that's all I have.
Oh, that's it?
These are the resources we got for clients. It has stuff about housing and employment and jobs and stuff. If you wanted to give it to
Yeah.
the other clients. I can email them like the hyperlinks because there's a lot of them.
Or the one, with that one case, what about the interlocks?
I think we have that. I
Some
know.
reduced maybe, some kind of reduced?
I don't know. I can check with somebody and see, but I know even with the one time we did it for the GPS monitoring, they only do it for 30 days. 'Cause they have to, I guess, get grant funding and it's only so much that goes out. But we could for sure do the virtual recording, but I don't think it's anything you can do about the device. Judge Brown, how much do you want to borrow? It's at 25,000.
25,000?
Yes, sir.
Yeah, just leave it at that. Yeah.
Which one's the grant for that? Which one?
So she got this from there, Jane. Just put 25. Yeah. 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 And why is it supplemental? Why is it supplemental?
So I believe it's Karen Smith. Yeah.
Yes, I do. I just want to know.
Eric has a response.
Mr. Brooker, we need to talk about,
I was just talking to Tristan Smith about it.
ready?
Yes, we are.
Coming up?
I was wondering if we can get Mr. Barrett taken care of, but it's okay.
Oh, well, yeah,
We'll do it all together. It's fine.
you can't go back. You know, and I was looking now, because you made the statement that, you know, hey, I'm a child. They can't just put me out. I looked it up. You know,
So I can't
according,
go back?
no,
Why not?
they don't
So,
want you back.
But like, okay, but like, I'm trying to, like, what I was trying to explain earlier is what the cop told me when she called the same day and told me I had to leave. They told me that since I was still, even though I am 17 and of age, even though since I'm still in school and it's my last year, since I still am in school, I'm still like under their care, so therefore they have to.
Tristan,
Not that I-
just give me one second. So Judge, what I understand is that the complainant witness is the older sister of Tristan Smith, is my understanding. Just for clarity, because I could not get into the actual report, is the grandmother asking my client not to come home?
I'll let you guys.
I don't get that.
Yes.
Guys, who did the rip?
Yes, Judge, the grandmother is who the complaining witness lives with, and the complaining witness and the grandmother are asking him not to return to the house.
What they're saying is that he has also allegedly been violent with grandmother as well, and that they're all afraid of him because of prior instances of aggressive conduct. And, you know, when I told you at the outset, all I want to do is honor the wishes of the complaining witnesses. And I wish I had a different answer for you, but I had them specifically go out to try to see if they were okay with you, because a lot of times, you know, time heals wounds, right? People forget, they relent a little bit, they'll be okay, well, we'll give them another chance. They're just, no.
So I'm trying to figure out, since the protection order, like the one that the judge gave me,
I'm doing a new one now. I'm going to redo one saying that you can't go back there, that you cannot have contact.
So how am I supposed to get to school?
And Judge, may I just I've just met my client, but my client is the younger of the two siblings. They do attend the same high school. This is an unworkable scenario for my client, because where does he go after he leaves this courtroom? I don't have an answer for that. So I don't know when the state spoke with grandmom. May have been right after the event.
30 minutes ago.
And as of right now, grandmom is saying that's
They both are saying
that's tough. Well, I understand the sister. I get that. Grandmother, I've never talked to her. I haven't had the opportunity to talk to her. But I would ask, firstly, and I believe I know what you're going to say, if we're able to reapproach you on this matter after a short time.
I've never not approached.
That's the first thing, because I have to do some more work on this. I mean, I just got appointed about 30 minutes ago. I need to figure that out because I'm concerned about my client's well-being.
As am I.
I
am too.
Scholarship offer to Baylor, is a senior in high school, has potential to do well in life. And at 17, clearly not a mature adult at this stage. And so I'm trying to help as much as I can. So that's the first thing. I thank you for allowing me to come back and approach them at some point. And I would just ask if the court will be willing to amend your conditions to make them no threatening and harassing conduct. Admonishing my client as much as you'd like. And if there's any inkling of disturbance.
Let's do this. What's grandma's phone number?
Can you give me social?
Yes, Your Honor. It's
Hold on.
grandma's phone number.
Stop.
Let me write it down.
Yes, please.
Yes. Can I borrow a pen? Thank you. Last one. 8.
What's grandma's name?
Karen.
Karen? Is this Miss Karen? Hello? Oh, they hung up.
I'm sorry, but the person you called has a voicemail box that has not been set up yet.
I wonder if they think it's you calling.
Goodbye.
Well, they may say Harris County, Judge, and that could be scary to some folk. And Judge, I believe you know what I was going to ask. I mean, a no threatening or harassing admonishment from you after having advised my client, understanding they cannot mess that opportunity up if it were granted. I think it at least allows us to sleep well at night knowing that my client is home and not homeless, because I don't know what he would do in the alternative. Just sleep outside, or I don't know.
He says he has a place to stay with his best friend. I know.
High school kids, Judge, and this is a senior year going into, seems like a pretty decent situation given the opportunities that.
How can I let him go back to a house where they don't want him to?
Judge, and even further, the concern is that he's already been admonished by the PC court judge to have no threatening or harassing contact. And he went home and tried to force his way into the house when he was not wanted there. He does not have a right to force his way into that home.
Maybe he didn't know at the time that he wasn't wanted.
The grandma informed the intake prosecutor that she told him, she stood in front of the door and she told him, you cannot enter this home. And he forced his way past the grandma, and the grandma had to try use force command as well to try to get him out of the house. He is obviously unwanted. I mean, they all want him out of the house.
I get it. We're not allowing him to go back.
Yes, Judge.
Now, Mr. Brooker's asking for is no threatening or harassing as opposed to just no contact.
But for what reason? They don't want contact with him. And justice right now, and to protect the community right now, the state's position, the only correct answer is no contact, and maybe after a cooling off period.
Oh.
And of course, I would have to hit the ready.
No, it's not that bad.
Or has been forwarded to voicemail. The person you're trying to reach is not available. At the tone.
One more time.
Call has been forwarded to voicemail. The person you're trying to.
And Judge, thank you for sharing that, because I did not know that. All of these facts are fresh to me. However, I think I understand the situation, having had the opportunity to speak directly with my client. Tristan's grandmother is almost 70 years old, Judge. She is not comfortable with Tristan's appearance, how she presents to the world. My understanding and belief is that this is the undercrux of this whole issue, is that they don't want Tristan around because of how Tristan presents. That's wrong. I mean, how people run their house is how they run their house, but is it a fear that something is going to happen, or is it because of the way Tristan looks?
Judge, we're assuming.
Let me just complete my position, because I don't have all the facts like you do. This is what I'm getting from the person that lives with her grandmother, his grandmother, that it's always been issues because of, as Tristan said, his sexuality. I don't think that's right. And so we're standing here, Tristan knows the seriousness of this, sees your face, sees everybody here, and understands if Tristan is admonished, there's not going to be any issues. Just wants to go back to school, finish out the senior year, and go on, maybe accept that scholarship to Baylor or go to another school that's local. It's all Tristan wants to do at this stage. Definitely understands the seriousness of this.
I understand and I get it, but we're still working on that, which is an assumption. I can't let you go back to a house that I know at this point they don't want you back. The only thing I know is that you've asked for no threatening or harassing contact.
So how am I supposed to go to school?
I'll talk to you about the judge's ruling.
These are things that you think about prior to picking up criminal cases, Mr. Smith. When you don't have other resources, you never bite the hand that feeds you. Burn a bridge because you never know when you have to cross that bridge. But the problem is this, according to them, it's not the first instance. And it's that's according to them. And if it was, then I have to think that they perhaps would want you to come back. But after multiple times, and they have a fear, they're afraid of you. That's what they're saying. I wasn't there. I don't know. But if we allow contact, what's going to happen?
Nothing's gonna happen. I didn't even mean, it wasn't even meant for her, my sister even get. I'm sorry.
What good? What purpose is there in allowing you to have contact is my point.
So I can go to school and I can graduate. And
whether you talk to them or not has no difference on whether you're going to go to school.
I understand that, but where I stay, it does. What I do, where I go after this does. That's what really matters. Where I go after this does. If I don't go back home, y'all talk about I can't go near her. Then
I want to honor their wishes, and if they're telling me they don't want you back at the house, who owns the house?
Grandpa and grandma.
That's who's telling me they don't want you back.
And just for clarification, I was going to ask for you to amend the geographic restriction part of the order and include the no threatening or harassing communication. Just to be clear, I wasn't just asking for no threatening or harassing. I want Tristan to go home so Tristan could go to school and do what Tristan needs to do. But we understand your order, and I'll explain it.
You know what's going to happen? I'm going to say, okay, he can go home. He's going to go home, and then they're going to get a call from the grandma saying, "Why the hell is he back home? Why is he coming here? We don't want him to come here." And then, God forbid, something even worse happen because tempers are flared. He's upset already as it is. If he goes home, it's a recipe for disaster. That's why we have these cooling off motions.
I'm not even upset. I just want to go home. Literally.
I can't.
I didn't miss school today to come here. I was supposed to be at school today. I missed school to come here. So for the
I will give you a school excuse, but Tristan,
all right.
If they're telling me they don't want you there, I can't do it. Now look, time heals wounds. So perhaps after a couple days, it'll change. The only thing I'm going to tell you is be nice. If they see that your behavior continues in the fashion that it has been, you're never going to go back. Some time has to pass. Perhaps after some time, they'll let you back. We can regroup on Monday if you want.
I'm okay, because it's not going to tell me right now that they've been trying to get me out the house since I've been 15. You can check how many police calls there have been, how many times the police have been to the house. Every single time it's because they either kick me out or they want me out the house.
So why give them ammunition when
I didn't give them any ammunition?
You have picked up an assault case.
You said I can't speak about my case, so I'm not gonna speak about it. So I can't speak about that. It wasn't intended for me to pick up an assault case. I'm telling you, I can't speak about the case, but everything happened by accident. Nothing that happened was supposed to happen. Nothing that happened was supposed to happen. Her doing what she did was not supposed to happen.
These are not accidents, they're choices. And once you realize that, and when you see that, perhaps changes can be made.
Okay.
These are no accidents. Okay. It's not an accident. It's a choice. And it's a choice that is made in the heat of the moment. And there are seldom times in life when you're put into this kind of moment that you have to step back and think to myself, if I do this, what's going to happen? If I say this, what's going to happen? You now know there are serious consequences. And I'm going to tell you now, with this assault that you have now, it only gets worse.
Right.
You have to have patience. Let's regroup next week. Let's come back. Let's call mom or grandmother on Monday. Perhaps on Monday, she'd be willing to relent to let you come back. I'm happy to talk with grandma. Perhaps you can reach out to her as well.
Certainly,
We
Judge.
can try to, smooth the situation out. Hopefully a couple days is sufficient to get them to calm down a little bit, and we'll go from there.
And here's the other issue, Judge. I also don't want to set the defendant up for failure. If I think you indicated defense that she goes to the same school as the sister, how do we approach that so that we're not getting a
The same
BVR?
classes. We have 2 classes together, so I'm trying to figure out if we can't be in the same class together, why we can't be in the same house together.
We're just now getting there. I didn't know this.
All right. It was all in the, never mind, I'm sorry.
It's a good question. How do we do it?
We're all working through it. I didn't know they were in the same class either. I did know that they attended the same school. They're a year apart. This is why we're here talking about this now, Judge. It's a lot.
Okay, so
Can we do like a no contact and no further
You're
pressing at school?
not to have any contact with this person. If you're in the class, same class, okay, don't go near them. Don't have any contact with them. If they try to have contact with you, just turn around and walk the other way.
So I can be in the same class, but not in the same house.
Correct.
Yes.
So we're in the same classroom, but we have 2 different rooms at the house and we can't be in the same house.
Your grandmother does not want you in the house.
Right. So what the officers told me, wasn't true.
I'm telling you now what your bond condition is. If you violate this condition, I'm going to put you in jail. You need to think about this now, because if you get out there, start acting, you have no one that is going to bond you out.
Anyways.
So when you're out there in the free world, Tristan, I want you to think.
Right.
Because if you go to jail and I make your bond $5,000, if you don't have anyone to pony up that money, what happens?
I'm just gonna be in jail then.
Right. You think you're going to graduate?
I might not already, so hey. And that's not no disrespect, I'm sorry. It's just something. I worked really hard to get where I am. Like, really, really hard to get this scholarship, to graduate. I worked really, really hard to get where I am. And now to be told that I might not even be able to graduate because.
Who said that?
Who said
that?
I'm not gonna be able to graduate. I'm telling you right now, I'm not
Why
gonna be
not?
able to graduate. I don't have nowhere to go. My best friend, that was an if, or that I have to go ask her mom, it's a whole bunch I have to do it. Like, wait, where am I? Don't worry about it. I'll figure it out.
I have to consider the safety of the community.
Right.
I understand that it's going to be tough for you, but actions have consequences. And I really hope that you appreciate what's going to happen. But I want to impress on you now that if you don't have anyone to bond you out, look at me. If you don't have anyone to bond you out and you go out there and do something you're not supposed to, or violate these conditions, or pick up a new case, it's really, really going to go sideways. You've dug yourself into a very small hole. It's not deep enough that you can crawl out of. But understand, you're skirting thin ice now. It's not the end of the world.
Right.
Time will pass, wounds will heal. But if you go out there and make moves that are not smart, choices that are not smart, you're only digging this hole deeper.
Right.
We can come back on Monday. I will try your grandmother again on Monday. I will talk to them myself.
That's in the notes.
I will allow you to report via Zoom if you want to.
Okay.
You don't have to come to court.
Okay.
Okay? But don't take matters into your own hands because it's really going to go south.
Okay.
You understand?
I understand.
He is the best in the business.
Right.
He will help you out for any issues that you need. He can get a hold of me at any time. There's no excuse for you to have contact with these people,
Right.
pick up a new case, or accidentally, but I fell down and I ended up back at my grandma's house. Don't.
Right.
Don't.
So if all my stuff, can I go get my things?
No.
So how much?
You cannot go back there. No means no.
I'll explain the orders also, Judge, and
Right.
try to work through how we can deal with it pragmatically.
Let's come back Monday. I'll try to call grandma again. I'll try to.
And I'll work on it too, and just talk about how we can work through it.
What about any MAC resources you can think about?
I'm thinking about it. I'm thinking about those now. I don't know if it'll happen quickly, but I'll.
Need money for anything? We'll give you whatever you need. Just say the word.
Yeah, I'll work on that today.
Okay.
Okay.
So that they don't miss school anymore. And let's regroup Monday.
Yes, sir.
Good afternoon, everybody. The Irish Demon back with another video. Today we got a lady who comes into court with a really strange name on the screen, and a judge picks her up on it straight away. Now, this lady is so entitled that she believes that she should never have to pay for her own rent. She makes the argument that it's everybody else's fault except her own.
Good afternoon. Are you Carrie Haney?
Yes.
You come in as Grinch 74. That means there were 73 Grinches before you.
I mean, she does kind of look like the Grinch.
When you come into court, you might want to consider what you come in named as. I had a terrible experience last year. But I'm a little better at it than I was. I also have a telephone number. I'm not sure who that is. Anyway, let's call this case. It's entitled Riverside Townhouses versus Carrie Haney. Carrie Haney has filed a motion for temporary relief from judgment and an ex parte order to stay proceedings. Rather than issue the order ex parte, I set it for hearing on short notice. I've been on vacation for 2 weeks, but I was in here last Tuesday. And last Tuesday, I asked the clerk to set the matter for hearing this afternoon, and she squeezed it in here. Sumchit Hart is here on behalf of Riverside, and their new manager, Lori Casino, is here. This matter goes all the way back to April or March, but we had a hearing on May 16th. Amy Lucas was here from Keystone. They were working on having a check. We were here again on June 17th, and we made a finding that the rent due was $3,903.61. We did a judgment which was due June 27th. Now here we are on the 25th of July. Ms. Casino,
Yes.
has Riverside received any money from Keystone?
Now, just to explain briefly what Keystone is, in this particular area, it is a community-based charity that assists people in paying their rent if they fall in hard times. Simply applying for it does not mean that you don't have to pay your rent. Also, they're not under any obligation. If they run out of money, they got nothing left to give you, and that seems to be what's happening at the moment anyway. Keystone should only be kind of used in rare circumstances when you really need the help, and definitely should not be looked at as a long-term opportunity to get free rent. But that's not going to stop this entitled Karen.
Not that
You broke up. You've received no money from Keystone?
No. We have not.
I emailed Keystone and asked them to join the hearing a while ago, and I haven't heard from them. So someone assisted you, Ms. Haney, with filing this pleading. Who helped you? Legal aid?
No, I did it online, but my SIRA application is still processing, it says.
According to who?
On my, when I go and check the status of it.
Have you talked to anybody?
I just got the email with the phone number this weekend, so I was gonna call today.
Well, all right. Ms. Hart, what's your position here?
Your Honor, we would object to any additional time given to Ms. Haney. The judgment was after a hearing, Your Honor, and the time has lapsed, not only for her to pay and stay there, but she didn't file the motion until the 29th. There is no defense to setting aside the judgment. It's been more than 30 days since the application for SARA. We'd ask for the judgment to stand, Your Honor.
Ms. Haney,
Yes.
let's pretend we're in a court hearing and you're talking to me rather than whoever is in the room there with you. They want you to move today. They're ready to do an eviction tomorrow. And they're asking that I don't grant your stay. They asked that
don't.
the-
See?
Let him talk. I'm sorry, what do you want me to know?
I just got another thing in the mail from Riverside, last week sometime, that I had on 30 days or something like that. And then I owed another $2,900 and something dollars. It wasn't even like the same amount that I got originally.
Well, it goes up as months pass. So let's
But it's
back
gonna
up.
go up though, because my rent should be zero. That's what I'm not understanding, why it keeps adding up if I don't pay rent.
What level of entitlement does it take to think that your rent should be zero and that it's everybody else's fault and everybody else's responsibility but your own? Now, the program that you signed up for, you would have easily been told that it's not guaranteed. I get it. People fall on hard times. We've all fallen on hard times. That doesn't mean that you can just sit back and say, it's all good. The community will cover it. Now the chickens come home to roost and you're getting all ratty.
Your rent was $765 per month, due on the first of each month.
Nobody ever told me that my rent was that amount. When I first moved in here, it was
I told you
$88.
that in court. Apparently you didn't recertify or something, but we had a hearing. You were here.
Yes.
We
And then
had the first hearing, just a minute. We had the first hearing May 17th. I adjourned it for 30 days. From May 17th to June 17th, 31 days.
Yes.
And we had a hearing at that time, and I made a finding that you owed $3,903.61 by June 27th, or you were subject to being evicted. You were there. I explained all the circumstances to you.
And I
You
understand.
haven't paid, and Keystone hasn't paid. So they were ready to evict you. And then you asked for this order to stay it, which has been an additional month. And they're asking that I deny your motion and sign the writ of eviction. I have it here in front of me.
Well, it says that if my Sierra app was still in processing, I could do that.
Who says that?
The law thing that I pulled up on the thing. That's why I filled out the application.
Oh, that sounded like great legalese right there. I think we better ask Judge Demon about this one. What do you think, Judge Demon? Well, she did say that she pulled up the law thing on the thing, so seems pretty legit to me. This chick knows what she's talking about.
Well, all right. Well, for one thing, I don't have any proof that your Sierra application is in processing.
I can send you a screenshot.
Well, you haven't filed anything and you haven't talked to anybody. All you've done is check your email.
I did file something with Riverside.
I adjourned the matter once, 30 days, which I am entitled to you're not entitled to a 30, well, you had it. You had it from June 27th or May 16th to June 17th. We already adjourned it for 30 days. And
he just keeps saying the same thing.
Yeah, Karen, he keeps saying the same thing for two reasons. Number one, that thing hasn't changed. Number two, you're clearly incapable of listening to what he's saying.
And they're asking that I immediately grant the eviction, which is pretty heavy stuff.
Being that they let people run around here breaking out, and I've got 4 kids, but they'll let stay in here that destroy their apartments. That makes no sense. Because the girl didn't like me, so she kept pushing and pushing and pushing on me. That's bull. I went and I went and re-signed a new lease like a week after the first time they sent me a court paper.
I went and filed it or signed it. I don't know why they don't have it. I don't know what happened to it, but I signed it. I sat down there for like an hour signing papers. And at that point, my rent should have been 0.
No, Karen. Number one, your rent should not have been 0. Your rent is whatever the rent set was, and then you will get a subsidy from a charity which would make it 0 for you, not 0 for them. They still need to be paid, and that is still your responsibility. Now, it sucks that you got 4 kids and you're worried about housing at this point. I wouldn't wish that on anybody, but society can't keep footing the bill for these things, and you can't then lash out at everybody just because you're not looking after yourself and your family. That is your responsibility.
But they just kept adding it on and adding it on, and she kept putting stuff on my door and putting stuff on my door. I don't understand how it works.
Your rent isn't 0, and that wasn't raised at the earlier hearings.
But it should be 0.
And they haven't paid your rent, and the landlord wants you to move.
Because it's processing. I can't speed it up.
You haven't filed anything that says it's in processing.
I did.
Let me see.
The last court date we had, it was in processing. She pulled it up and said that they would try to push it through. So I did.
That was on June 17th. Well, they didn't.
Yeah.
They haven't paid it.
And it is still processing. I can't do anything about it.
Well, neither can they. You haven't paid your rent. So you're saying, well, someone else is supposed to pay my rent. Well, they haven't paid it.
I'm not saying someone else. I'm saying the application that I applied for, I can't push it through any further. I can't jump to the government and make them push it through.
Yeah,
I can't. This is bull. She was just on here with us the last time and told them she would try to push it through. That's not my fault.
Ms. Hart, are you willing to give 10 days?
Your Honor, this case has been ongoing since April. That's not amendable to the complex. She's, as you can see, very combative. We would just
the
want
one time. I have been on these calls for freaking 4 different times and I've been fine because I'm tired. I'm tired of it. They've been picking and picking at me.
Calm down.
Yeah, she's clearly not a combative person. I get it. Sorting out rent can be very stressful. I've just recently been there myself. It ain't fun. But screaming at the people who are trying to help you is not the way forward. You didn't pay your rent. Now, I understand you were under the impression that it was going to be free. Well, it ain't. And it's on you as an adult and as a mother to ensure that you go and sort it out.
I'm sorry that
I
this
have
is
been
the way
quiet
it
this
is.
whole time and they don't let me talk every time.
This wasn't my idea, but you're not paying your rent. You're asking the government to pay your rent. The government hasn't paid it. I don't know why they haven't paid it, but they have not. They've
It's
also
still
not
in
reached.
processing. I cannot speed up the processing. It's not up to me. Marvin, stop! You're not making it better for me.
Who's there with you?
I have tried and tried and tried. I've applied for stuff. I filled stuff out on the computer.
All right,
I've gone through everything they told me to go through.
Now, I know you said that you tried filling out stuff. What about filling out a job application? Now, some of you might be looking at that and saying, that's pretty cruel, and she's got kids and it's hard to do. Let me be clear. A lot of people out there are doing that every single day. Now, I don't know, maybe this lady has mental health problems, maybe she has a disability. If that were the case, I'm sure there's specific assistance for her in that scenario.
Well, they didn't pay your rent. And for that, I'm sorry.
Processing.
All right, this is going to be very unpleasant. Keystone has not responded to them.
And
They
I
haven't
tried
responded
to
to me.
communicate, but this girl up here that they had as the manager didn't like me. She refused to talk to me every time I tried.
your motion for ex parte order to stay the eviction is denied. What you effectively got is a 1 month stay from June 27th to July 25th. But I've signed the writ of eviction. They're not even willing to give you any additional time. So they could start tomorrow with evicting you. So they want you to go, and they want you to go immediately, and I don't like that much.
I have 4 kids. Like, I can't just go.
With all due respect to this lady, I know it's tough being evicted, especially when you got 4 kids. Despite what another YouTuber might say, I myself have never been evicted. I also don't have any kids, so I'm not aware of how tough that would be, but I can only imagine. But here's the thing, folks. This has been going on for months and months and months now. A month ago, she had to go to court to get a stay on this eviction. That basically gives you 30 days to sort out your affairs. What's recommended in that scenario is either you come to a resolution with the owners, or you prepare your ass to move out.
I would immediately contact Keystone, even if they probably won't accept Keystone's payment because they want you to move.
But they have druggies out here breaking out windows. That's cute.
Fair enough. There may be people in that same apartment block that are causing trouble, breaking out windows, doing all that horrible stuff. That's between them and the owners or the authorities, depending on how bad it is. Just because people are doing that doesn't mean that you don't pay your rent. It also doesn't mean that when you don't pay your rent, that you don't get evicted. Now, all in all, this is a pretty horrible situation. But this lady was given opportunity on top of opportunities. Opportunities like free rent. A lot of us have to get up in the morning and work very hard to pay our rent. Most of you watching probably do, or a mortgage. Again, I don't know this lady's circumstances. It hasn't been brought up, so I assume it's nothing really that bad. Because if it was, she would be able to use it to her advantage in this scenario. You might argue that having 4 kids and having to pay for childcare would stop her from being able to go out and get a job. Millions of people the world over have to make that work every day. It's not that I don't have sympathy for her, I do. Despite her being so entitled and aggressive, I do have sympathy for her, but there has to be a stopping point. There has to be a point where all of your opportunities coming again and again and again have to stop. And it seems like this is where it has. You could tell because the judge even said it himself. He didn't like having to do this, that it wasn't going to be a nice thing to do, but it has to be done at some point. Anyway, folks, thank you so much for joining me today. I hope you enjoyed this video. If you did, make sure and give it a thumbs up, hit that subscribe button and leave a comment down below. Just hit 22,000 subscribers, so I want to thank you all so much for joining me. It's been awesome. If you want to support the channel in other ways, you can do so by hitting the PayPal link down below. Leave me an old tip in that tip jar, or consider getting some beautiful Irish Demon merch. We'll catch you in the next one, folks. Slán. Yeah, Karen rolls into court, and basically she kind of essentially refuses to leave. She gets a little bit testy. So let's have a look at this, and let me know what you think down below. I definitely gonna need some nicknames for this one.
I still have people. Bell Asset Management versus Denette Malik.
Ready, Your Honor.
Hello.
Hi, how are you?
I don't know.
I'm looking for every great recommendation I can receive from you today, sir. I have been in a very horrible assaultive position.
Okay, let me.
Since I left your-
Hold on a second.
Okay.
State your name for the record.
Denette Malik.
Okay, go ahead, Ms. Malik.
Well, I entered your courtroom honorably last year at this time. I came in as a plaintiff.
Okay.
And when I swore in, I gave some information about one company, Akram Rashid, merging with a new owner. At that time, I, the customer, was not given the respect, nor any other tenant in my building, underneath the laws to meet this person as a consumer. It is of complete responsibility for a new company to acquire the permission of the tenant where money is concerned to enter a good consumer relationship. This did not happen. Time proceeded and this maintenance company decided to enter person's property with no permission, started to manipulate them, stealing possessions, stealing
Hey,
automobiles.
ma'am, can I ask you something?
Sure.
Are you crazy?
Is this your motion to set aside the judgment?
Well, I did set it aside and we met that agreement. An attorney named Kevin Callahan sat in a court with me as a plaintiff. According to the law, there are no attorneys allowed. So I tried to motion in at the end of August
No
because I
attorneys- no,
recognized.
Hold on, no attorneys allowed where?
When I first met with you, Your Honor, I went into a small claims. And I was underneath the impression through the courses of the law that there were no attorneys allowed in a small claim. So something kind of got jangled up.
Yeah, your
I
brain.
presented charges.
Ma'am, hold on.
Okay.
Okay, because I want to make sure that I've got everything in front of me. Was there a small claims case?
Yes. And at that time, we made an agreement
Go ahead.
that after August,
She
which was
underneath the
Akram
impression.
Rashid's current lease, that there were not supposed to be any changes to, yet that wasn't the case. I would be on a month to month. I raised my right hand. Kevin Callahan, yourself, and I made that agreement. He swore to me, my mother, which then reported it to my banks. I reported it to my private attorneys in New York City that managed my work. And I contacted the courts. I talked to him verbally over the phone from his office in St. Clair Shores. And he stated to me that I swear, you're gonna receive that sheet of paper. I waited and I waited and I waited. Spring and summer came to fruition and I called the courts. It's getting, later in the year. Where's the sheet of paper? It was as easy as that. There was no failure of me to make the payment. I still have the finances set aside.
Here he comes.
I feel like they are trying to retaliate against me because I've continued to make reports, which is my sole discretion. I have the right to do that. Between the Michigan State Police that were called on numerous occasions by other.
Ma'am, I'm gonna have to stop you because I'm not clear what you're talking.
Well, I think that there's a position here where there's charges that he wanted to dismiss, but because he did not fulfill the obligation that he promised me, by August, I was being manipulated and they're not following through with their original
Manipulated by
agreement.
whom?
I, yourself, and Callahan last January coming into February. We sat in the Zoom conference. I presented the paperwork that was unorthodox. of
Judge, if I
one
may,
owner
I
and
have
another
information
owner.
on this. I can,
And this change of ownership will not affect your
face.
lease agreement. She put unless otherwise indicated in your current signed lease. Well, unless otherwise means I can't do what I'm claiming I'm gonna do. She broke these laws.
She being whom?
EJ Elizabeth Jefferson, who claimed to be a property manager that no one had ever met. There is no legible address. The Attorney General states that she's not a registered or licensed person. The federal offices told me not to be in business with them.
Ma'am.
Yep.
I'm gonna tell you right now, you've lost me.
Well, from the very beginning, I presented, the first time I came in to see you, I presented both pieces of paper.
Ma'am, stop for a moment.
Okay.
I had them pull a small claims case involving yourself against Bell Management.
Yeah, they did things
That
that were
was-
illegal. Fair housing.
Ma'am,
The lawyer's face.
that was over a year ago. I would like to say I absolutely remember that,
Yeah.
but I don't.
I'm in dismay myself, sir, because I made that agreement with you. I clearly don't allow a judge or myself to be taken advantage of by an attorney's office.
Well, I don't know that I've been taken advantage of.
I believe I have been.
Okay.
I would
that's
not
fine.
enter your courts to present this witness information as very
Ma'am,
imperative.
stop for one moment.
Okay.
I don't
Let me
think she can.
hear, I've heard from you for a while. Let me hear from the other side.
Okay.
Mr. Callahan.
Thank you, Judge. Kevin Callahan, P78273, representing Bell Asset Management. The matter that Ms. Malik is speaking of was a previous matter, a small claims matter that was filed against my client in conjunction with a non-payment of rent matter that we filed against Ms. Malik. Those matters have been decided. Those matters are closed. It has no bearing on this matter whatsoever. This current case, Ms. Malik even admitted she's on a month-to-month tenancy. We provided a 30-day notice to Ms. Malik. She never showed up to court, so a default judgment was entered back in October against Ms. Malik. We subsequently filed a writ of eviction. That writ was signed by Your Honor, and now we get this motion to set aside that default 2 months after the default was entered, alleging that no attorney present and it was against her rights. And I'm as lost as you are with this, Judge. There's no basis to set this judgment aside. Ms. Malik is a month-to-month tenant. She has to vacate the property. However, I will say for the record, because I'm not going to let my reputation possibly be besmirched on the record here of doing anything illegal or improper, Ms. Malik has called my office and left over 120 voicemails accusing me of crimes under the federal law that don't exist, made threats against me, my family.
What?
Ms. Malik, I allowed you to speak. Please allow me to speak. She's made threats against my bar license. She's made threats against my family. She's made threats against my office staff. It has been deplorable what my staff has gone through with Ms. Malik over a situation that is a simple month-to-month termination, and Ms. Malik refuses to leave the property, Judge.
What?
We're just asking for that judgment to stand and the writ to stand so that my client can move forward.
Leave the property. I never made any threats to anybody's family. I never made any threats to anybody. I did call the office. I asked him for the sheet of paper that he promised. He said he would give me a month to month after August. I said, what is going on? I said, give me the oral confirmation or the written confirmation, and I'm going to continue to pay the money from August onward. I asked your court, I said, may I please have the sheet of paper?
Ma'am.
I did not threaten anybody.
Okay, fine. I don't know anything about that. And I'm not.
If he made an agreement
ma'am,
about a month to
ma'am,
month, why am I?
Ma'am, you have interrupted me numerous times.
I'm sorry.
That needs to stop.
I did not threaten anybody.
Okay.
Okay.
Fine. Always
Just
two sides to
horribly
the story.
rude.
But the reality here is you're before the court challenging, you're asking me to set aside a judgment to stay the writ.
She then told me, she flip-flopped with me 3 times. She put another sheet of paper underneath my door, asking me, E.J. Jefferson.
Ma'am,
she
that
asked
has
me if I
nothing-
abandoned my unit. Then she tried to take the money out
Ma'am,
3
okay,
times
ma'am,
in
I'm gonna,
September
you know
and
what I'm gonna do,
October.
ma'am, here's what I'm gonna do.
But there was no order.
Ma'am, I'm gonna pass
She
the matter.
asked me to move out.
Quit interrupting me.
Yeah, she's still
Quit
trying to take the money.
interrupting me. That's warning 2. On the third one, I act.
Ooh, contempt.
You're before the court to set aside the judgment and the writ.
Yes.
So that the record is clear, the judgment was entered for failure to appear at 2 hearings. First one being October 6th, and then on October 20th. I issued of 2023. I issued the judgment.
Because I thought that the month to month would be honored. That's all. It's all that he gave me. It was all the information I went by, was what I was sworn in. When I'm underneath oath, an agreement is made,
Underneath
nothing
oath.
happened other than me calling his office.
She said when I'm underneath oath. Oath even.
Was sworn in. When I'm underneath oath, an agreement is made, nothing happened other than me calling his office and asking for that sheet of paper. I diligently, respectfully, and responsibly, as
Ma'am, you can have a seat before I find you in contempt. That is now the third time that you have interrupted. Have a seat. Counsel, just wait. I will read the case at some point.
Oh, thank you, Judge.
Alrighty. So essentially,
try this one.
He put her in timeout.
Trudy AV versus Don McMahon. Okay.
We're supposed to be gone.
He basically put her on the naughty step, essentially. All right, let's see if we can find where they pick all of this one up. Yeah, she's just another one of these ones that just doesn't know when to stop. Like, I mean, how many times does the judge have to tell her, like, stop interrupting? But you see, people like her, I'm not just saying like women like her, I mean, genuinely just people like her in general. They're so used to always getting their own way, to being the boss. She's probably the boss at home. You know, she tells everybody what to do, tells her kids what to do, tells her husband what to do, all of this kind of stuff. And is so used to that, she comes into court and thinks that she can do the same. It's like, well, you're picking the wrong judge to try to pull that crap with. All right, so it looks like we might be back on. Here we go. All right. Like making threats and stuff. Like, come on, lady.
And for the record, Judge, again, Kevin Callahan for plaintiff P78273.
State your name again, Miss Malik.
Denette Malik.
All right. Let me, before anybody else says anything, because this is going way far afield. The only issue before me is the order that I issued in October, which was the judgment, and then the writ of eviction.
Well, I failed the October. I don't know how. I got confused. I'm not accustomed to the courts.
Ma'am.
That's a you problem though, isn't it? Like, that's not the judge's fault. It's not the lawyer's fault. I mean, come on, man.
But if at any given time, here's what the problem for you, Miss Malik, and I'm just going to be blunt about it. That judgment went out from the court shortly after my signing. All right.
Sir, may I ask something of you? Once an agreement.
The judge and all of our eyes were all there at the same time, I'm pretty certain.
Sir, may I ask something of you? Once an agreement is made in court, isn't that you respectfully gave me the month to month. He told me if I dropped the charges on his group, his client would agree to give me a month to month. I mean,
then you're going to have to file a new claim that alleges that. That's not before me.
That's why I motioned in August.
No, but that is not before me today.
This is how I will state it.
No,
wait.
Wrong. That's not before me.
I can pay the money. There was never a failure. I swear, I had the money aside.
They want you out.
I didn't.
It's not about the money.
They asked me to pay. There was no probable cause in any level. I called his office respectfully. I asked him for the sheet of paper for the month to month that was agreed upon after August. She put a renewal underneath my door. If she wanted me to leave, why was she sending me a renewal? She tried to take the money out in September and October, that would mean I'm still on a month to month. I just said, where is the paperwork to confirm that? My bank has it on the record, JP Morgan Chase, September and October.
Ma'am, they want you out.
But she asked me to renew.
Ma'am, I don't know about any of those conversations. They have properly been granted a judgment for possession. They properly filed the writ or the order of eviction. I've signed the order of eviction. There is no basis, and I've listened to everything you said to me. There is no basis for this court to set aside that judgment or to stay the execution of the order of eviction or the writ of restitution. There's no legal basis for me.
I can't pay the money that was agreed
They
upon.
don't want the money.
Hmm.
This was
Even though
a-
she tried to take it out in September and
Oh
October.
my God, lady, listen.
This is a termination of tenancy case. I don't know anything that they've done regarding taking it out. This is
They did. They
termination.
tried to take the money out.
Okay, ma'am, that's fine. I don't know that. But even if that were true, the judgment in this
What did
case,
I have not done anything though, Your Honor. I mean, this is against the law. I
no, what would be against the law is me to grant your relief you're requesting. Because they, like you have rights, they have rights. You brought this before the court. And I'm gonna say it again to you, so hopefully it'll sink in. They properly got a judgment. Upon properly getting that judgment, they properly requested an order of eviction. I issued the order of eviction. That order of eviction, the judgment, because you have not provided a basis that will stand. Your motion.
I did nothing after August other than oblige where a month to month was concerned. That was the agreement.
So
I
what?
did not refuse payment. There was no probable cause.
Month to month can be cancelled at any month. That's why it's called month to month.
She put a renewal underneath my door. I says, well, where's the sheet of paper if you're trying to renew? And then she's flip-flopping back and forth with me. Well, I'm like, okay, I thought I was supposed to be on a month to month. That's all it was. She lied to me. And then she lied to me again. And then she tried to take the money out 3 times. So it got me confused. I'm like, well, then am I on a month to month? The bank has that on record. So I came in thinking that if I spoke the truth, because I was sworn in last year and it was agreed upon that I'd be on a month to month after August. That was it. It was as simple as that. I contacted your courts on numerous occasions prior to the end of August.
And maybe you don't understand. I just issued my ruling. Your motion is denied. What I will indicate is that the escrow will be held for 15 days and then it will be released back to the defendant. I will not pay the escrow over to the plaintiff. It will be released back to the defendant in this case. Thank you.
So what is the
Thank you,
time
Judge.
frame? May I have till the end of January, sir?
Ma'am, you're operating on borrowed time. I signed the writ
I cannot just,
December 3rd. I signed the writ December 3rd.
to have a moving truck in, please, sir. I mean, it is the dead of winter. I have no problem moving out. I've been looking for another place because I don't trust those people. First, they're making an agreement with me and then they're flip-flopping. Could you please, a little courtesy where this is concerned, please?
You've not granted me any courtesy in terms of your talking. Why should I grant you any? But despite that, the writ will not execute prior to January 16th. So I will give you, that grace of 10 days, and if I hear anything else, I may take that.
So I have to be out of this place by January 16th?
They cannot execute the writ prior to that date.
Okay.
Because otherwise they could do it tomorrow.
Right.
I am giving that 10-day I'm giving you that period. I'm not giving you to the end of the month. I'm giving you that period. That's as far as I'm going. I'm done.
I don't know what I did, and I feel swindled.
Judge, should I enter a order to that effect, or will the court? produce
Yes,
the
sir.
order?
Please, please.
Okay, thank you. I will
Prepare
email
an
it.
order under the 7-day rule, please.
I'll do that. Thank you, Judge. Have a great day.
You do the same, but too late.
The escrow itself, when does that get repaid to me?
You need to listen to what I just told you. 15 days, I will release the escrow back.
May I enter a bank account number or an
No.
address to you?
No,
I have to give you a different address because if I'm not going to be living here,
ma'am, you can give it to the clerk's office any day. I'm done. You need to leave my.
Bye, Felicia. Oh, man. Well, that was one hell of a day for Judge Simpson. I feel bad for anybody being booted out of their home like that. It's obviously not nice, don't get me wrong, but at the same time, like, how many times do you need to be told, lady? It looks to me like she was just looking for any excuse to just cling on there as long as she could. Thank you so much, Armageddon's Fire, for the 199 super sticker. Really appreciate that. And Dalek Beck has been a member for 19 months. Says, long live the young Irish Demon Army. Thank you so much indeed. I really do appreciate that. Well, that was a lot of fun.
Yes, it is. Good afternoon, Ms. Rice.
Afternoon. Yes. Good afternoon.
Sorry.
You're all right.
Good afternoon, Trish.
Good afternoon, Your Honor.
All right, let's start over again. This is file 24979LT. It's entitled U.S. Bank versus Patricia and Lawrence Rice. Ms. Rice, Lawrence was here early, the lawyer was here early, and I was willing to start early, but I forgot about you. So I said, well, let's wait for Patricia Rice to log in, and you're here now. This is a foreclosure action. There was a bank foreclosure on this property on Man Road some time ago. The property's been sold at a sheriff's sale. And attorney G. Douglas Tuma is here from the Trott and Trott Law Firm representing U.S. Bank. We were here on July 29th, and we learned that Lawrence is in the house and Patricia is not and has not been for some time. There was a more than a year redemption period that's passed. The property was not redeemed, and at this point, the bank wishes to foreclose and take possession of the property. Is that correct, Mr. Tuma?
Yes, Your Honor, in large part. I think at the very end, you misspoke. You said that we wish to foreclose and take possession of the property.
Yeah, it had
We wish
been
to evict.
foreclosed.
Yeah,
Yes.
the foreclosure is completed. The 1-year redemption period is expired. There's been no circuit court challenge to the validity of the sheriff's deed. My understanding is Patricia Rice is out of the property and doesn't claim any interest in the property, but Mr. Rice is, and we are not aware of any of the very limited defenses that are available in a possession-only case post-foreclosure. We have not seen any raised in this case, so we would ask for a judgment of possession.
Mr. Rice, what would you like me to know?
Right here, June 10th, 2022 is when I filed for my disability. My first paycheck is December of 22. I have made every attempt with Select Portfolio Servicing that if you, and remind you, Mr. Middleton, I asked for a jury trial when I asked my case to be removed from the United States of America because I'm not going to get a free trial with you oath takers moving in and out of my house. And Mr. Middleton, I will show you your paperwork that comes from Trout Law that says right at the top of it, Team J, Patricia Rice. Right at the top of my deed in abstract, my description of my legal property. And Mr. Middleton, Mrs. Patricia Rice started moving out in 2005. Mr. Middleton, the courtesy report sent to you on Discover and Capital One credit cards
that explains that since 2005, she has moved in and out of my house and took at least $45,000 with her when she went, maxed my credit cards out. Mr. Middleton, you have all this. U.S. National Bank, U.S. Bank National Association has all this. Capital One, Discover, Pay Express. Every Pay Express card registered in that woman's name will show you the last time she left my home was about $14,000 cash, and I was maxed out in credit card debt and 25% interest. And paperwork coming from Trout Law says Team J. Mr. Middleton, from the time I left here at court last Friday, my poems, my presidential speeches that I've been writing, and the good Lord woke me up for 2 weeks straight and told me to push a pencil, not to mention 10 years of my poems like Dirt Cheap, and my lottery tickets. Every lottery office I bought a ticket from, I want to retailers' cameras, because Mr. Dirt Cheap and a lottery ticket was in Mr. Johnson's office with his security cameras. Everything is on security cameras that I've asked for, Mr. Middleton. And I asked for my case to be removed last week. So that means I want a jury trial. And that means I want it removed from the United States of America's U.S. Bank. It's just like Donald Trump, and cameras everywhere, and have me on recorded. And Donald Trump is involved with this. And I want Donald Trump's cases, along with mine, removed from the United States, because I'm not going to get a fair trial with oath takers, because we've already proven that here in St. Joe County with your phone. God bless, amen. So we can keep doing Trout Law and Team J with this St. Joe County and very nice oath takers that want to intimidate me when I stand here and speak my very right as a United States American citizen, that I want not only a jury trial, I want it removed from the United States of America, because I'm not going to get a free trial. And Donald Trump's, Joe Biden, and all the emails are coming with me. Then if not, every phone number I have that this county has blocked my emails and my texts, you're all under arrest. God bless, amen. Do I need my citizen's arrest handcuff, or does he have a shouting pair? That's what I have to say, Mr. Middleton. But for the beginning, and for Team J, Mr. Middleton, Credit Union 401. I am going to speak my piece as an American citizen, as an oath taker right here behind me. That comes from his office, Trout Law. It may not be him, but it came from Trout Law. That Credit Union 401 in the United States of America, and I guess we better go with this. I want a jury trial. You have wellness checks and everything else called on me. Temporary insanity is what I plead. God bless. Amen. Temporary insanity, and you have it all on your security cameras and your wellness checks. And Robert Small, Jay Scott, Zach Aminga across my street, invading my privacy like Mrs. Rice. And forgive her, because I love her with all my heart. There is a spot in there, but I'm worried about me now. Okay? And I am filing bankruptcy as of June 10th in the United States of America, because I do believe it's my right, because you guys, I waited 207 days and I did not disrespect the Social Security Administration's office, because they have 207 days. And if they have 207 days, U.S. National Bank Association has all my credit cards. They have all the proof. I should have 207 days. Every day that it takes for my disability to go through. And you're taking seniors and Americans home that are disabled and holding up Jill Scott and bipolar and Big Pharma. Big Pharma, bipolar medication keeps you bipolar. The cure is inside of you. It's reading, writing, and arithmetic. That's bipolar cure. Because bipolar kind of medication ain't doing nothing but keeping you bipolar. Read the symptoms, brother. Read the symptoms. And this ain't bipolar. No, you listen to me. This is my time. You gave me permission, and you are gonna listen.
I think we're in the manic stage of bipolar, but
you play manic stage, Mr. Middleton. This is anger. Because you know what it feels like when you can't keep people coming in and out of your house, and it's law enforcement? Do you? You did the search warrants. God bless, amen. You did, Mr. Middleton. This county. And just like the Maine, when I mentioned Dave Scott and he looked at you, same thing Officer Lackey did when I called him about the very turtle that they exterminated. It was probably an endangered species that you want to play your little games stood about this damn tall. And it was on Facebook and it was on Man Road because the car went by. I said, just a minute, let me go. This is weird. And I'm going to post it.
Just let him go. I'll give him till 2:30.
In bankruptcy, I want a jury trial. I am pleading temporary insanity, and I want to file bankruptcy. And it's my disability that I have to wait on the government has to wait on me. And children being molested in Constantine, Michigan public schools, and you all are going to tell me I got to wait till 2:30. Mr. Middleton, 401. Credit Union 401, United States of America. Instead of taking it, if they were smart, they'd empty their accounts or tell you, let us open up the credit union with $100 billion and take the taxes and the Social Security from it so the government gets their help they need. God bless, amen. It'd be for the American citizens. It'd be for me. It'd be for my disability. God bless, amen. And it's just the beginning. But I did ask for a jury trial when I said move my case out of the United States of America. That is my God-given right. And Donald Trump and all the cases and all the security cameras, I want you to think about it, Mr. Middleton. They're coming with us. God bless and amen. Because I need it for my trial.
All right, thank you.
You're welcome.
Ms. Rice, anything you wish to say?
I did not take any money from him, sir.
All right, well, you don't have any interest in this property.
Pay express cards, sir.
Is that true, Ms. Rice?
And all the fuel on the Capital One cards.
Just a minute.
Mr. Middleton, everything is proof on the Capital One cards. You have it.
Well, that's
and they
not
discover cases that you,
before the court.
your court system.
Mr. Tooma, I really wish I had a judgment here, but I don't.
Your Honor, we'll email one over quickly. I've got it in front of me. I just wasn't sure of this court's procedure for filing. But...
All right, the email address is 3bcivil@stjosephcountymi.org.
Before you leave, sir?
So just a sec. Elaine, look for this judgment, and as soon as you get it, please bring it in the courtroom.
Before you leave, sir, Mr. U.S. National Bank, are you there?
Your Honor, I just have to step to my scanner.
Are you there, Mr. U.S. National Bank? I would like for him to see this camera right here. In the cage that you sat right here last week and agreed to, that I caught COVID in it, and there was no way to escape it for 9 days. And you sat right here in this courtroom last week and agreed there was no way for me to escape COVID. Do you want to show Mr. U.S. Bank this phone? Because I want him to see the cage I was in, that Mr. Warren Buffett decided to fire me instead of paying me for the COVID that I caught in his cage. Mr. Middleton.
No, I don't think he needs to see it. I accept if you were in a confined space.
Because you sat right here in this courtroom and said there was no way for me to escape COVID in that cage.
Probably not. No. All right.
Probably not. No.
Mr. Rice, the cold hard truth is this has to do with a payment for property that you're living in.
And I would have had, if I would have got my half grant, would have caught it up in that cage, Mr. Middleton, that you sat here and agreed to.
Yes, now stop.
And it's registered in this court. God bless, amen. Okay, I'll stop.
All right, I gave you.
But you will remove this eviction, this foreclosure, and this possession from this courtroom and the United States of America, and that is my given right as a jury trial. God bless, amen.
All right. I don't know where I'd remove it to, the outer limits. Anyway, you have 10 days to vacate this house or you're subject to being evicted. You also have 10 days to appeal it. 10 days from.
And forgive me, dear Lord, for I have sinned, Mr. Middleton. I am allowed legal help, and I have called legal aid every day this week but 3. God bless, amen. You keep sitting there doing this, Mr. Middleton, because I'm coming for you, brother. And hopefully I can find a real old taker.
Your Honor, I must have.
And I hope I live streamed, dear Lord. God bless, amen.
I must have written down the email address incorrectly because it bounced back.
3bcivil@stjosephcountymi.org.
Donald Trump and Vincent DiCarlo, Pandora's Box in St. Joe County. God bless, amen.
All right, sir. If you wait outside, I'll make sure you get a copy.
No, I'll hear anything you have to say, because you're not gonna run your mouth after I walk out the courtroom.
Well, you have 10
You can be
days.
trusted about as far as I can pick you up and throw you. You're probably not that far.
Well, I'm heavier than I once was, but yes, you have 10 days to move or you're subject to being evicted.
You have right now to remove yourself from the courtroom. You corrupt official. God bless, amen.
All right, you're good to go. You wait out in the hall.
Pedophile. We're gonna find them all.
Sorry, I'd go through that, Your Honor.
Oh, it's part of the job. Miss Rice, I know you've been struggling with this for a while. There's no sense to stir the pot. It is what it is. He's in the property. It's been foreclosed on. The redemption period has passed. Miss Rice, my recommendation to you would be you contact Sergeant Bruce Morse at the Sheriff's Department in 10 days. When they go to execute this writ of eviction, it's going to be very unpleasant. I know you do have some things there that you claim belong to you.
Right, Your Honor, and I would actually request the court to really review our request. I'm not sure if you went through our responses, but
I spent my holiday reading this.
Okay, thank you. So we included a lot of the documents that we have, and we're actually in the process of getting.
Excuse me.
Aaron is being
Excuse
given
me.
the power to
Please stop talking.
rewrite laws.
Please stop talking.
And we believe that you're actually unfairly ruling and that there's actually some unfairness going on.
And to per se defendants.
But they have not.
Excuse me, don't interrupt me again.
Hey everybody, I'm coming to you from the couch studio today. Have still problems in my own studio, still a little bit under the weather, but we're way better than I was for the past few days. Definitely getting back on track. I have some really exciting news coming up at the end of this month. I'll be coming over to London for a few days, so definitely going to be meeting up with a few people there. Anyway, I got this case from a really great YouTube channel you should check out, Lone Wolf Usel, I think is how it's pronounced. I'll link it in the description down below. But we have these very interesting folks. I was going to say young ladies, but I'm not 100% sure what the etiquette there is or whatever. But this judge is taking absolutely no nonsense. One of these individuals claims that the judge is being racist towards her, despite them both being of, well, what appears to be the same race. Also, she is a they, them, so they're being discriminated against for that, allegedly. Just because the opposing lawyer is white, it somehow means that they're being discriminated against because he knows what he's doing and they don't know what they are doing. Anyway, you're definitely going to want to stay tuned to the end of this video. It's absolutely epic, and this judge takes absolutely no nonsense.
All right, let's call file number 23-140446, Devon Burt, Edipong Agapan, and Anaya Amuchi versus Banyan Property Management. We have a motion for default judgment filed on behalf of the plaintiff, and we have a motion to compel discovery filed on behalf of our defendants. Could I have your appearances, please?
Nanaya,
filed on behalf.
I think somebody's video's on. But Nanaya Amuchi on behalf of the plaintiffs. And just for the record, Your Honor, we submitted 3 motions. So we also did a motion for deemed request admitted, and then also protective order, that's included in the deemed admitted, and then the default judgment. Thank you.
Hi, my name is Devon Bird. She, her, theirs pronouns.
Thank you.
Young Adiakman, she, her pronouns.
Thank you. Counsel.
Good morning, Your Honor. Aaron Cox, P69346. I'm appearing on behalf of the defendant counter plaintiffs.
All right, let us commence with the motion for default judgment filed on behalf of our plaintiffs.
Yes, Your Honor. We filed a motion for default judgment. Prior to that, we filed a notice and a motion to deemed the request to admissions admitted due to the fact that the last time we were here, we went on record and all parties believed that the discovery was satisfied. At the time on May 2nd, the defendant had still not filed a response to our request for admissions. And so at that last hearing, we informed the court that we would be filing the motion to deem admitted. And so based on that, we are also asking the court to move in favor of default judgment according to MCR 2.603, and which says a party may be found in default for either failing to plead or answer or for improper conduct such as discovery abuses, which is also quoted in Kalamazoo Oil Corporation v. Bowerman, 242 Michigan Appeals 7587, 2000. And we hope that you will enter into that today.
Mr. Cox.
Your Honor, I'm going to address first the issue being raised about whether or not my client has deemed admitted responses to requests to admit. I'm not sure whether or not the court has that before it today, but I think it's appropriate to address based on the argument made by the plaintiff here. Our responses were timely served on April 19th, 2023. Those were served by first class mail and pursuant to the court rules MCR 2.107. That service was complete the second that we put that document in the mail and sent it to the plaintiff. What the plaintiff has alleged in their motion is that because that document was not received by the court by that date, that somehow the responses just don't matter, and that's just simply not true. MCR 2.312 subsection B subsection 1 very clearly states that the matters are deemed admitted unless and until a response is, quote, served upon the requesting party within that 28-day time period. The plaintiffs in this case were certainly served with those responses in writing by mail on April the 19th. So there are no admissions that are admitted. But even if there were, Judge, MCR 2.603 is not a vehicle upon which this court can grant the default for that alleged failure. MCR 2.603 is a court rule that very clearly says that if a party does not appear or defend that a default would be appropriate. Well, clearly, Your Honor, we have appeared, we have defended throughout the entire course of the case. And while certain segments of 2.603 would permit the court to enter defaults for like not appearing for a hearing or a trial, that's not what we have here. They're simply alleging wrongly that admissions were admitted and therefore a default is appropriate. That's not contemplated by MCR 2.603, and the court should deny the motion.
Let me hear from plaintiff. What is the day that your admissions were served?
Yes, so our first written discovery was.
No, ma'am, I'm asking for, sorry, plaintiff, I'm asking for the date of the request for admissions.
That we sent to the defendant?
Yes, counsel. Yes, plaintiff, yes.
Yes, so we sent our first written discovery on March 28th.
On March 28th?
Yes, and so.
He has 28 days from that day, right?
Right, so that was until April 25th to respond. And to this day, again, the court has not received an actual, like we haven't received it and the court has not received it. And in all of our documents, we always file a proof of service to ensure that we have the evidence before the court. There has not been any proof of filing served on the defendant's behalf. And even at the last hearing, the defendant said that they were satisfied with discovery, even at the time when we raised that still in the record, there had not been any response to our request. And to this day, there still have not been any response to our request filed before this court. Aaron Daniel.
Let me stop you right there.
Okay.
Mr. Cox?
Your Honor, we do in fact have a certificate of service on the document that was sent to them. I personally put the document in the envelope and posted it on April the 19th to the plaintiffs. It was mailed out. I did it.
The problem that we have with the motion, and of course prepared to rule on that motion, is that the court rule provides 28 days for the time to answer, and the answer is deemed to be done when it is served, that is by first class mail or personal delivery. And in this case, there is on behalf of the defendant, answers to the interrogatory with a certificate of service inside of 28 days from which the request for admissions were issued. The motion for default judgment must therefore be denied. I don't have to get into the question of whether 603 is the appropriate rule or not, because the request for admissions were timely served.
Your Honor, where's the what is that based off of? Because we would like for the defendant to show his actual evidence of serving it. Like there's no proof of service or filing. And then even on that, the only documents we received was with his motion to compel, which included the answers that he claims he sent, but even in that, it's not notarized. And according to the court rules, it's also deemed admitted when the documents are not notarized and it was not done under oath and there was no verification for the documents that he included in his motion to compel. So the motion to compel is the first time we saw any form of answer, but even then there's no notary, it's not notarized. And so that is actually a violation of the statute and also provides for the request to be deemed as admitted.
Mr. Cox?
Your Honor, there is no requirement for responses to requests to admit to be notarized. There is a requirement for interrogatories to be sworn to, not notarized anymore after the changes to the discovery court rules. The interrogatory responses that were attached to our response and that were served on the plaintiff, in fact, were verified by Erica White, the authorized signer on behalf of the defendant.
Okay, the court, I'm convinced Mr. Cox's interpretation is appropriate. It's what the court rule says. Your motion for default judgment must be denied. Now, is there anything you wanted to move forward? Anything else on behalf of the plaintiffs?
Your Honor, so just to clarify, what is the court basing the service on?
I find that the request for admissions, which are the basis for your motion for default judgment, were timely answered.
When were they answered?
Excuse me.
Okay.
I find that they were timely answered, and therefore there's no basis to deem them admitted. There being no basis to deem them admitted, there is no justification for a default judgment. Thank you. I've ruled. You have absolute right to appeal my decision, but that is my rule. Is there anything else you want to bring to the court's attention today?
Yes, in there, we also had a motion for a protective order to prevent a defendant from harassing us, undue burden. He has sent a number of motions to compels, even though if you look at our responses to the request admission is thoroughly answered. And we've gone through each of the request admissions and the interrogatories and have thoroughly answered it. But this is the second time I think that the defendant has requested a motion to compel for things that we've already answered thoroughly. And also, Your Honor, we would ask that if the defendant, because again, we have not received the answers to our request to admission. So if the defendant can either file that in the court or resend it to us, like there's no proof of filing or service only based on what he says. There's no actual documentation of that. And so we haven't actually received it. So we're also asking the court to request that he do that so that we have
let me stop right here. I have made my ruling in regard to the request for admissions. If you disagree with it, you may file an appeal. I would suggest you read the pleadings filed on behalf of Mr. Cox, which included, among other things, his answers to the request and a certificate of service of the same answers. Now, Mr. Cox, you had a motion concerning discovery, and they have filed responses. Are you satisfied with those responses?
I am not, Your Honor. So this is actually the second time that we've had to file a motion to compel. We filed our first motion on or about April the 19th. And I think about a day before we were scheduled to argue that motion, they did in fact submit responses. The first motion was premised solely upon the absence of the response at all. Now that we've had an opportunity to review those responses, we've filed the motion that's before the court today, asking the court to compel further, more specific responses with respect to the requests and their interrogatories. And as I've laid out in my motion and briefly summarized, we asked 11 document production requests, including documents supporting their claims for damages, and we got nothing. Literally not a single document was produced. We asked a number of interrogatories that asked for details about what witnesses they have or are aware of, what inspections they performed, what representations they alleged that the defendant had made, and damages that they alleged to have incurred. And they didn't give us any of those responses. And while they did give some very thorough responses to a couple of the interrogatories, they were not responsive to the other requests, and they didn't place a proper objection on those responses at all. So we'd ask the court to compel them to provide full and complete responses to those document production requests and interrogatories within a reasonable period of time.
Were any documents provided in response to the notice for production of documents?
Yes, because the majority of the documents that the defendant requested, we have already provided it in our original pleading, which included.
That's not the way the rule works. The way the rule works is that if they ask for production of specific things, you are supposed to provide those things in response to the notice for production of documents.
We did provide some document. We provided the documents that we had, and even in our answers, we said we provided all the documents that we have in our possession at this time, and we will make it available to the court on a rolling basis. That's what we responded to. We were not we were not fighting the discovery. And then we also named that some of the documents that are requested are already in the defendant's possession, and that it would be unduly to reprint the things that they already have.
Okay,
And
well, let's stop right here in that regard. This is a lawsuit that you brought. They're empowered under the court rules to defend the lawsuits using, among other things, request for production of documents, request for admissions and interrogatories. And I don't understand the argument that something that you claim that a document that's going to be used at your trial is too burdensome for them, for you to produce.
Oh, well, that's because he asked for a very broad, he asked for any and all documents from the whole last 5 years. And so we said we already supplied the documents that are relevant to the last 2 years. And that would take time for us to find those documents. We're pro se documents. So we have provided a lot of the documents he requested, we provided it. You know, if you actually look at their request.
All right, let's stop right here.
Mm-hmm.
Mr. Cox, you will draft an order adjourning your motion to compel until June 27th at 11 o'clock. You will draft another order denying the plaintiff's motion for default judgment for the reasons set forth on the record. I am going to give you an opportunity, plaintiffs, to supplement your production of documents, interrogatories, should you choose to do so. If you don't choose to do so, then I'll move forward. But you've told me that you have not provided a number of documents that he requested in his notice for production of documents.
Right, we've provided some of them, and the other ones we said we would provide it when they become available.
But they haven't been provided. That's the point I'm making.
Right, yeah. So, but
So
I'm just
let me tell you how
properly. We responded
how this is going to happen.
Mm-hmm.
You're not understanding me. You brought the lawsuit. You have an absolute right to do that, but they have a right to defend. They have a right to use the tools under the court rules, and the court rules provide they can say, show me the documents. So what I'm going to do is I'm going to adjourn to give you an opportunity to provide the documents, supplement your responses. Because when we come together again on this, if you haven't provided the documents, I'm going to have to move in another direction here.
Right, Your Honor, and I would actually request the court to really review our request. I'm not sure if you went through our responses, but
I spent my holiday reading this.
Okay, thank you. So we included a lot of the documents that we have, and we're actually in the process of getting inspections. We're in the process of getting a lot of the documents that they requested. So we're not trying to fight or combat the discovery. In fact, I think it's the defendant who's trying to combat the discovery because they actually haven't really responded or done anything. So
okay,
I appreciate your time for reviewing our documents.
That's what the taxpayers pay me for. So, Mr. Cox, do you understand the court's orders?
I do, Your Honor.
2 orders. Now, the next time we're together, given that discovery is closed, and given that there's been an opportunity to supplement any, how to say this, perhaps omitted unintentionally documents, I'm going to be very, very forward and strict on this. We're either going to have compliance or we're going to have sanctions. That's the way it's going to be. Now, what I would urge you all to do, and again, I can't order you to do anything. I would urge you to consider. Let me ask one more question. What has happened on the landlord-tenant case? All I need to know is, has it been concluded or not?
It has been concluded, Your Honor.
Okay.
It's being appealed currently. So there's actually
There's been an order.
there's a bond placed on the landlord tenant pending the appeal.
What was the order of the court? Possession for the defendant?
Yes, sir.
All right. Okay, so that matter is closed out.
There's a bond pending the appeal, so it's actually being appealed in the.
It's really, that was just an information for me, because as I indicated, and I earlier declined to consolidate the cases. The court has a landlord-tenant division, and in that we bifurcate frequently two things: possession, which is all, as I understand it, was decided in the landlord-tenant matter, and any claim for money damages, which is where we are on this file. So we will be together next June 27th at 11 o'clock. I'll be looking forward, Mr. Cox, to your orders.
I'll have them over.
Accomplished today.
Thank you very much, Your Honor.
Your Honor, I do have something to say, if that's okay, please.
Identify yourself, please, and please say what you want to say.
Yes, my name is Adidiong.
Okay, please say what you want to say.
Thank you. Yeah, so just to summarize something, this is not to really change your opinion, because you have definitely shared your opinion and we've heard you. But just to say some things for the record, you know, as the court person is taking the court transcript. So as of today, May 30th, we have provided overwhelming amount of evidence to show retaliation and harm and harassment, right? We have court registers, proof of services. We have pictures. Plaintiff has even, defendants have left us to our proofs even. We've showed ample evidence, different leases. We have shown pictures of the home. We have shown email correspondence with the defendants and us. We have shown many evidence. The only evidence that Aaron has submitted to us as of May 30th to us in our home and even to the court records is the 2019 to 2020 lease. Or sorry, 2021 to 2022 lease. That is the only evidence Aaron has ever submitted from the beginning.
All right, let's stop right here. This is excuse me.
Aaron is being given the power to
stop. Please stop talking.
Rewrite laws.
Please stop talking. I would like to avoid muting you. You will refer to him as Attorney Cox.
Attorney Cox has also harassed us, right? That's why we had the motion for protective order, because he continues to harass us. He continues to oppress us in violation of court rules when we continue to supply ample evidence. The evidence we have given to him surpasses the evidence he has given to us or the court. And so just wanting that to go on the record, right? Because yes, we have multiple court cases and multiple investigations because we are being harmed.
Don't fade away.
Oppressed.
Keep talking close to the mic. You're fading in and out because you're moving away from the mic.
Well, I hope the court recorder was able to write those out in the transcripts.
Just so you know, there is no court reporter. This is a jazz recording. It is a multi-track recording, which every time one person speaks, they're put on that one single track. So there's a track for you, there's a track for Mr. Cox, there's a track for each of the plaintiffs. So if you decide you want a transcript, there won't be any of the blurring that you frequently get with court reporters when several people try to speak at once. We're on the JAV system and have been all the time. Anything else anyone else want to say?
It's still being recorded and we'll try to get the transcript, but we'll also still argue it in the appeal for sure. Because definitely we have ample evidence. We have supplied Aaron Cox and proof of that evidence, and he has supplied no evidence whatsoever and also has answered to our stuff late. And that is in the receipts that we have provided to you over and over again, and that we have, and that we will continue to produce, right?
All right. Your appeal is not of my decision, because now you have an absolute right to appeal any decision I make, including the two decisions I've made today. But your appeal is as to whatever it is that happened or did not happen in the landlord-tenant division. All right, We'll talk to everybody again, June 27th.
We just want to, one more thing.
Please.
Yes, so, in the pattern of what we've been discussing around the unfairness and the inequality and the injustice of this court, just want to reiterate that my co-plaintiff said that the only thing that Attorney Cox has ever supplied has been a lease. And we believe that you are actually unfairly ruling and that there's actually some unfairness going on. There's a lot of rules that we have mentioned today and mentioned in our briefs that continue to be disregarded before this court. And we just want to, again, put that on record that we are being treated unfairly. We are pro se plaintiffs. Aaron Daniel Cox is being paid hundreds of dollars an hour to represent defendants and continues to, and has a whole law firm of people who are researching, who are supplying things, and he's never to this day filed a proof of filing. It's required by this law, by the court, to file a proof of filing, but you're basing things based on his words. But he will not file a proof of filing before this court. Everything that we have filed and gone before this court and filed a proof of filing so that we can say, actually, it was served on this day. We're not just depending on our name and our say as an attorney or as a man or as a white person. It's unjust.
All right, I understand your objections. Again, you have an absolute right to appeal any decision that I make. And I would further point out for the court rules that the court rules apply equally to plaintiffs and to per se defendants.
But they have not.
So, excuse me, don't interrupt me again. I would further point out that at least on one occasion, you told me that you were an attorney licensed to practice law in the state of California.
In DC, I was once licensed in California, but my first introduction to the state of Michigan is facing an eviction. So I just got here. Now I'm having to.
All right, thank you.
Eviction. All right, it's very unjust. So I'm studying.
I understand you. And again, you have an absolute right to appeal any decision that I make.
Absolutely. And we have absolute right also
to interrupt me again.
Unjust
right.
in this court.
I'm going to mute you now because I'm tired of being interrupted. If you are, as you say, an attorney licensed to practice anywhere, at minimum, you ought to have some understanding of courtroom decorum. So we will talk to you all again.
And I understand justice too.
Please do not interrupt me again.
You are using two different.
I'm going to mute you, ma'am. Thank you. We are on the.
I'm not a ma'am.
We are June 27th at 11 o'clock. Thank you all for coming in. We're off the record.
Thank you, Your Honor.
Read the court rules.
You're applying different court rules. You're applying different rules to Attorney Cox. There's no proof of filing. There's no proof of filing. There's no notary. There's no proof of filing. He hasn't done a lot of things, but y'all keep having side conversations and applying different rules.
Ma'am, we have. Excuse me.
I'm not a ma'am. I'm not a ma'am. That's part of the discrimination we're facing.
Plaintiff, we have.
You're applying different rules to Attorney Cox than you are to us. He has never filed a proof of filing before this court. He has no evidence about anything he's done. It's just his word.
I'm not going to continue this.
Well, that was a bit of a clusterfuck, as we say. Yeah, that was quite something. You know, when in doubt, pull out the race card, blame sexual orientation, blame gender, whatever the case may be. You know, whatever you do, don't blame your own negligence. Anyway, folks, thank you so much for joining me. I really hope you enjoyed this. If you do, make sure and hit that like button, comment, subscribe, all that good stuff.